This account was created to provide information on how current immigration laws apply to certain factual scenarios. There are many, I suspect, who are worried about their immigration situation, but they're not sure if they should speak to an immigration attorney. Keep in mind, and I cannot stress this enough, that immigration law is unbelievably fact-specific. So even if you think that your situation is nearly identical to one of the ones that I go over here, you still need to speak to an immigration attorney personally. Even the smallest factual changes can make a big difference in the outcome. That said, this is not legal advice. I'm hoping this will merely help educate people as to how the immigration laws work, because I know there are a lot of anxiety exists in certain immigrant communities. Also, immigration laws and procedures will likely change quite a bit in the months to come. So what might be accurate and current at the time of this recording very well could change in the weeks to come, maybe even tomorrow. All right, so this individual has been in the United States since the mid-90s when he entered illegally. In 1999, his employer agreed to start an immigration case for him. They filed the labor certification with the Department of Labor in 2000, and the labor certification was later approved. After the labor certification approval, the employer filed the I-140 visa petition with USCIS on his behalf. The I-140 visa petition was ultimately denied by USCIS because they found that the employer failed to show that the company had the ability to pay the wages of this individual. Apparently, the company had fallen on hard times over the last few years and their profits had declined. The individual is now married to a lawful permanent resident, and the couple would like to know if they can file a green card case. When you're doing a green card case like this based on 245I, the issue is when the labor certification was filed, okay? Back in 2000, when the labor certification was filed, was it meritorious in fact? Meaning, was there a legitimate employer-employee relationship here, okay? And in this case, the labor certification was approved ultimately. So that should be enough to prove that it was approvable when it was filed. Now, years down the road, during that employment-based immigration case, they filed an I-140, and that was later denied. Well, what I've seen in the last couple months is that a few USCIS officers have said that because the I-140 was later denied, even though that might have been in 2007, so 7 years after the labor certification filing, because that I-140 was later denied, that the whole case was not approvable when filed, when it was done in 2000, and therefore, this person isn't 245I eligible. Well, that's just plain wrong, okay? I've seen it now in a couple of cases in the last couple months, and we've fought that argument, and in one case, we even had to do an appeal, and we won on the appeal or the motion to reopen. We won on that. But it's an issue that just keeps getting brought up, and you need to know that just because the I-140 is later denied, that doesn't have anything to do with whether the labor certification was approvable when filed. Ability to pay the wages is not something that has to do with the labor certification. It only has to do with the visa petition. So if you have this type of a case, if you have a 245I that's based on employment, you need to know that this issue could come up when you're doing your green card case, and you need to be prepared for it. You need to be able to argue this with the officer, or your attorney needs to be able to argue this with the officer, because it's a completely false basis for a denial, but we are seeing these happen. And if you get denied and you have to do a motion to reconsider or an appeal or fight this in immigration court, your case is going to get a lot more expensive. So you want to make sure from the outset that you know what you're doing and you're ready for this argument to pop up. Hopefully that's helpful. If this is something anyone is dealing with, we're happy to come and have you talk to us about it. We have handled a few of these cases in the last few months, and we've gotten them approved. It's unfortunate that this has even become an issue with USCIS because this law has been settled for a couple of decades now. So it's strange that they're bringing this up, but it is what it is, and feel free to reach out. Good luck.